under CIPAA 2012, The Way Forward post-Anas. My name is Ellen. I'm the manager of BicTok, and I'll be your host for today's session. Before we begin, let me run through a few housekeeping matters. Kindly ensure that your Zoom username reflects the name under which you registered. This will allow us to accurately mark your attendance and, where applicable, issue your certificate of participation and CPD points. If you have any questions during the session, please feel free to leave them in the chat box. Alternatively, you may also raise your questions during the Q&A session at the end. To guide today's discussion, we are honored to have with us our moderator, Mr. Shanta Mohan Balasubramaniam. Mr. Shanta has over 36 years of experience in legal practice, primarily in construction, civil and commercial litigation, insurance, tort, arbitration, adjudication, and mediation. He has handled numerous complex construction and contractual disputes and is a seasoned arbitrator and adjudicator. We are truly privileged to have him moderating today's session. Without further ado, please join me in welcoming Mr. Shanta Mohan.
Thank you, Ellen. Good evening, ladies and gentlemen. Welcome to BicTok number 35. As you can see, BicTok has been very active over the years in promoting arbitration and adjudication. Let me first thank BicTok on behalf of the panelists and myself for the invitation to moderate and speak in this BicTok session number 35. Thank you also to Ellen for the kind introductions. Okay, today's session is entitled Adjudication Payment Claim under CIPAA 2012, The Way Forward post-Anas. This promises to be a very interesting and live topic in view of the Federal Court majority decision that set aside the adjudicator's decision because the adjudicator relied on a clause in the contract that was not pleaded in the payment claim. The strong dissenting decision by Justice Mary Lim is compelling, and it requires, I'm sure the panelists will give due mention to all these of the judgment in due course. Now, today's session is actually broken up into two parts. The first part will be where the speakers will individually speak on the allotted topics that have been given to them on this main topic, of course, and followed by a session where Q&A and sort of round table where questions from the floor and even for myself to the panelists to maybe delve into the topic of Anas and implications to how this case has impacted payment claims. Okay, the three moderators, the session will start with Mr. Dinesh Nandrajog, who will take us down memory lane in a sense from the initiation of payment claim, payment responses, and the jurisdictional issues under Section 27 and so forth, tracing the history of how we came to where we are with Anas. This will be followed by Mr. Wong Hin Lung, who will delve into the case proper, the Federal Court decision, both the majority as well as the dissenting decision. And Ms. Serene Hugh will take on the topic of the impact of Anas on payment claims. The second half of the session, of course, will be a roundtable session in Q&As from the members of the audience who are attending, and also questions posed by me. Okay, so it will also be good if participants can interact and put in your questions while the session is going on so that we can tabulate and address the questions as we go forward. Now, it's my pleasure to introduce three eminent speakers we have. I must say, it has been a pleasure. I had the pleasure of having two of the speakers appear before me in adjudications, and one as a learned opponent on the other side in an IP matter, nothing to do with construction. Let me first start with the ladies first, of course. We'll start with Ms. Serene Hugh. Ms. Serene Hugh is partner with Messrs. Harold Lam Partnership. He has 14 years in legal practice, primarily in the areas of construction, infrastructure, and engineering disputes. She is an empaneled arbitrator and adjudicator with the AIC and is the current president of the Malaysian Society of Construction Law. She is also a director of the International Group of Arbitrators, otherwise known as. The next panelist is Mr. Hin Loong. He has been in practice for more than 25 years and is a fellow of the Chartered Institute of Arbitrators. He's also a fellow of the Singapore Institute of Arbitrators, SIAP, and the Malaysian Society of Adjudicators. Mr. Hin Loong previously hailed from Azman Davidson, and before he started his own practice and styled as under H.L. Wong, So and Company, with another partner, Mr. So Jing Han. He has appeared as counsel and sat as adjudicator in many adjudications and since the inception of CIPAA in 15th of April 2014. The final speaker, the third speaker is a panelist, is Mr. Dinesh Nandrajog, who was called to the bar in England in 2010 and also admitted in English bar in 2011 and the Malaysian bar in 2012. He's a partner in his firm, Nandrajog, a partnership, and his areas of expertise include general litigation, ADR, and has specialized in contract, company, construction, debt recovery, and so forth. Dinesh has appeared as counsel in numerous adjudication matters, and he has co-authored several publications and is a member of the AIC panel of adjudicators. He's also a member of the Bar Council Arbitration and Construction Law Committee. Now, without further ado, may I just invite Mr. Dinesh Nandrajog to begin his session. I think he's got about 15 minutes. Let's keep to time. Over to you, Dinesh.
Thank you, Mr. Shanta, for the very kind introduction. I'll just get straight to it. Everyone would later see, or those who have already read the decision, the federal court decision in Anas, it really deals with what can an adjudicator adjudicate upon, i.e. his jurisdiction or his capacity. What can he decide and what can he not decide? And so that really is the central issue in Anas, and that's what the federal court, the majority and minority panel dealt with. And so really, I would say that this talk today deals with the issue of jurisdiction of an adjudicator in CIPAA proceedings. So as Mr. Shanta pointed out earlier, what I will do is I will speak a little bit about jurisdiction of adjudicator, how that is established and how we deal with it and what has happened before the case of Anas. And then my friends, Mr. Wong and Ms. Serene, will then deal with the case of Anas and how we move forward post-Anas. So I've got some slides. I believe Bicom will email the slides later, but I'll just share screen for everyone's benefit. Right. So at the outset, the jurisdiction of an adjudicator is established in Section 27 of the Act of CIPAA. And subsection 1 says the adjudicator's jurisdiction in relation to any dispute is limited to the matter referred to adjudication by the parties pursuant to sections 5 and 6. Now, I'll deal with sections 5 and 6 in the coming slides, but before I go there, what is jurisdiction really? And in the High Court case of Terminal Parentis, the Judge Justice Lucy Singh had identified the different types of jurisdiction that there is in CIPAA, in adjudication, and it was identified as 3 types. One is core jurisdiction, which means whether the subject matter of the dispute is one which CIPAA has conferred upon the adjudicator, i.e. is there a construction contract, is the project carried out in Malaysia, is any of the parties in the adjudication a party to the contract, which is the dispute before the adjudicator. So that would fall under something called core jurisdiction in CIPAA. And then another type of jurisdiction is known as competency jurisdiction, and this really deals with the administrative or procedure part of the process. And as I've stated there, it deals with the validity of the appointment of an adjudicator, i.e. has he been appointed correctly or pursuant to the correct procedure, whether the director was the one who appointed him or was it some other person, whether was he appointed in according to the time frame set out in the Act, etc., etc. So it deals with more of procedure. And the third type of jurisdiction is contingent jurisdiction, i.e. subsequently when the proceedings start, whether the requirements of CIPAA have been complied with by the parties, by either the claimant or the respondent. So these are the 3 types of jurisdiction that governs or really sets out what an adjudicator's role is in CIPAA. Now, and very interestingly, the complaints that one would have in regard jurisdiction would really only fall in 2 categories. One is known as absolute lack of jurisdiction, and the other is known as excess of jurisdiction. And these are usually the complaints that parties would put forth in a contest or in a dispute relating to jurisdiction of an adjudicator. Now, absolute lack of jurisdiction would come in a place where a party is saying that the adjudicator did not have jurisdiction at all. From the outset, the adjudicator could not have heard the matter or did not have any powers or jurisdiction to hear the dispute and determine the dispute, the issues surrounding the dispute. So, meaning from the outset, there was no jurisdiction at all. The second type of challenge that is always mounted is something known as excess of jurisdiction. This would mean that the adjudicator had the jurisdiction to decide upon the dispute, so there was no issues whatsoever from the get-go. But when he delivers his decision, in his decision, he then goes beyond the parameters that have been referred to him, parameters of the dispute that have been referred to him. So a very quick example would be if the dispute only revolves around issue A, B, C, D, but in his decision, he then deals with A, B, C, D, but also deals with an E and F, an additional issue. So that would mean that the adjudicator then went beyond the parameters of the dispute that was referred to him, and then that can be mounted as a challenge of excess of jurisdiction. Now, why these are very distinct and very different is because it deals with the method of how you challenge these issues. So if you're challenging the jurisdiction under an absolute lack of jurisdiction point, then you don't go under section 15 of CIPAA, because the section 15, there are only 4 limbs that you can apply, which I'll come to in a bit. But absolute lack of jurisdiction, a party would then seek a declaration from the High Court. So you would file an originating summons at the High Court, seeking declaration that the adjudicator did not have jurisdiction at all material times. And so the proceedings, whether it's ongoing or it's completed, is to be declared null and void, etc., etc. But if it's excess of jurisdiction, the second part of it, then that's where then you would fall in the 4th limb in section 15 of CIPAA, where you can apply to set aside the decision on grounds of excess of jurisdiction, that the adjudicator went beyond the parameters that were referred to him. All right. So now that I've set out what is the jurisdiction and how his jurisdiction is established, now let's look at Section 5. Now you will remember Section 27 established the jurisdiction of the adjudicator pursuant to Section 5 and Section 6. Now Section 5 is, I would say, the most important, because now, although there are cases, and a lot of people like to say that it's likened to be a letter of demand, and I'm sure a lot of you out there are practitioners, you would know that, a letter of demand really is the precursor to you filing a suit in court, or like a notice of arbitration before you actually attempt the appointment of arbitrator and then your statement of case, etc. But because of, and especially the decision of Anas, which we'll go through later on, payment claim actually is extremely important, and I would think is the start of your pleading. As practitioners, we know that parties are bound by the pleadings in court. So similarly, I would akin payment claim to it being a pleading in your adjudication process. And so why it's very important is because of that. And what goes into the payment claim, which is extremely important, are these 4 items which have been set out in Section 5, subsection 2 of the Act. And these are the elements and the details that are required for you to have a valid payment claim. A, B, C. So amount claim, due date, identify cause of action, description of works, and that this payment claim, the form or in a form of a letter, has to be made under Section 5 of the CIPAA Act. And why these elements are important? Because if there is any element which is missing, then the jurisdiction, if you guys would remember, Section 27, the jurisdiction of the adjudicator is really established through Section 5 and Section 6. So if Section 5 is not complied with, there can then be a challenge on the jurisdiction of the adjudicator. If Section 5 has not been complied, whether the jurisdiction stands or not, that would then depend on what the non-compliance of Section 5.2 is, right? So just very briefly, the payment claim is to contain those details. And I've also put my second last bullet point there. A lot of people would, I've had people come up to me and ask me, look, what is the difference between payment claim and adjudication claim? Why can't I just put everything in adjudication claim? So my answer to that is because of Section 5.2, which has very mandatory requirements there. And the real description is the payment claim is to contain the details of the claim and the cause of action. So it really is the start of everything. And the adjudication claim is to supplement what you have stated in your payment claim. So you already have the claim, details of the claim and the cause of action in your payment claim. In your adjudication claim, you expand on that, on what the details of claim are, giving the nature and the description of the dispute, and of course what the cause of action is, which ordinarily would be breach of contract and breach of what clause, and then expand and close it by saying what is the reliefs that you're seeking for, right? So that is Section 5. Now, but of course, there are many cases, this is pre-Anas, I'm talking about pre-Anas, where the courts have said, look, let's take a more relaxed approach to the payment claim. And the reason for that is because in CIPAA, like in arbitration, you don't necessarily need a legal counsel or a lawyer to represent you in these proceedings. You can get claim consultant to act for you, or even you can be acting, rather the party itself can be acting for itself, because all they need to do is the forms are readily available in the Act, download the forms and fill up accordingly. So that was the rationale why the courts have taken a very, I wouldn't say a very relaxed, but some sort of a relaxed approach to the mandatory compliance with Section 5 sub 2. And so one of the cases that has been cited by all the other courts is the High Court case of terminal parentis, where Justice Lee Swee Seng said, one should not be unduly critical or technical to the point of exacting an overly demanding treatment of a payment claim when it comes to whether it has met the requirements of 5.2b, 5.2, etc. Right? And the most important is, as long as you can identify the nature, the details of the claim and the cause of action, that should be sufficient. And I think the federal court case of view esteem, the infamous case, very succinctly put it and explain what this really means, what payment claim is really all about. The federal court said, if the payment claim relates to progress claim number 28, the jurisdiction of the adjudicator is limited to this progress claim and nothing else. The payment response is likewise limited to the answer to progress claim number 28. It is the dispute that arises from the payment claim that the adjudicator is required to adjudicate upon. So, i.e., if progress claim is your complaint and what you're claiming in the adjudication proceedings, you can only claim for number 28, and the adjudicator's jurisdiction is also limited to arguments and evidence and issues relating to progress claim number 28. The adjudicator cannot then go and determine progress claim number 29 or progress claim number 27, etc. So that really is what payment claim is and how the jurisdiction of the adjudicator stems out of a payment claim, right? Now I'll go on to section 6 as well, which talks about the jurisdiction of the adjudicator as well. If you remember, section 27 says section 5 and 6. So section 5 is always issued by the unpaid party and usually the claimant. And the payment response really is a reply to the payment claim, which is issued by the non-paying party, the party who doesn't want to pay the claimant. Usually the subsequently becomes the respondent in the proceedings. And really the payment response is something which is fairly simple. Section 6 of CIPAA doesn't place too much of a burden on the non-paying party to set out a very lengthy, detailed payment response. All it has to do is set out as what has been stated in section 6. As long as there's some dispute, how much is the dispute, and to be served within the 10 working days requirement. And what the courts have also held in this is pre-Anas, is that there's no specific format for the payment response. So even although there is a form in CIPAA for payment response, but even if you don't follow that form, it can be done via a standard letter or even a lawyer's letter or even the claims consultant letter on their letterhead within a page or two is sufficient to be a payment response. And notwithstanding that, even if there is no payment response that is filed, the federal court case of view, esteem, and in fact section 6.4 of CIPAA says that it is then deemed that the entire claim as set out, or whatever issues that are set out in the payment claim by the claimant or the unpaid party, is deemed to be disputed. So the non-paying party or the respondents really don't have to fear that, look, if I don't file or I don't serve my payment response within time, I'm stuck. Because section 6.4 and view esteem says, no, don't worry, it is deemed that you have disputed everything anyway, right? So that is section 6. Now coming to the issue of setting aside, or rather the issue of jurisdiction. I've gone through the issue of section 27, where the jurisdiction is established pursuant to the payment claim and payment response. The payment claim, I've set out also how the jurisdiction is established via section 5 sub 2. Those elements must be fulfilled in a payment claim to give the jurisdiction to the adjudicator to adjudicate upon. And if it's not fulfilled, then the adjudicator can't do that. And those two elements of lack of jurisdiction and excess of jurisdiction, I've also spoken to you of how to go about it. But in most cases, and from my experience, the lack of jurisdiction, i.e. issues of whether there's a construction contract, whether the party is a party to the construction contract, whether the project is in Malaysia, all these things usually do not crop up because, I mean, we're all practitioners, we all know those are basic things that really nobody would get wrong. You would obviously sue somebody who is a party to the contract. So the complete lack of jurisdiction is very rare, is a very rare challenge in courts. The majority of the arguments or contentions that are put up to set aside deal with excess of jurisdiction. And all these cases that I've set out actually deal with arguments of where, like I mentioned earlier, where the adjudicator has the jurisdiction, to deal with the proceedings from the get-go, there are no issues whatsoever from the start till the end. By the end, I mean the adjudication reply. So there's a claim, payment claim, the payment response, the adjudication claim, response and reply. During that proceedings, during that time, there are no issues whatsoever. But then the issue of jurisdiction then comes post his decision. When the adjudicator then delivers a decision, he then, if he goes beyond the parameters that we have, then that's where the arguments of excess of jurisdiction then come into play. Now, I set out these 4 cases where I felt that the arguments of excess of jurisdiction were very interesting, but I believe in all these cases, the setting aside on Section 15D on this ground of excess of jurisdiction was dismissed. So it's not easy to deal with an argument of excess of jurisdiction, but of course, again, this is all pre-Anas. Now, when Anas also deals with this issue, and I think I will leave that to Mr. Wong and Ms. Serene to speak on. So what I've done is just set out the background of jurisdiction, how it's established, and what are the contentions that we can have, or how you deal with issues of jurisdiction, lack of jurisdiction, or excess of jurisdiction. Yep, that is that.
Thank you, Dinesh. That was a very nice introduction that will lay the foundation of where when we discuss Anas post the implications of Anas. Very well. Now, can I just invite Mr. Wong Hin Loong to share with us his thoughts about the judgment of Anas, the federal court decision, the majority decision, and the minority decision as well. Thank you, Mr. Wong.
Good evening, ladies and gentlemen. Thank you very much, Mr. Shanta Mohan, for the kind introduction, and to BicTok as well for inviting me as a speaker for this BicTok today. I just wish to share some presentation slides setting out the decision of Anas, both the majority decision and also the minority decision. I believe you can see that on the screen.
Yeah, it's good.
It's good, huh? Okay, thank you very much.
Can you just expand it? It'll be great.
Okay, give me a second. Is it better now?
Yes,
perfect.
perfect.
Okay, thank you very much. Now, so the brief facts of the case is, of course, we have the claimant here, Anas, who's the main contractor, claiming for reimbursement of professional fees and charges payable to his consultant. And then reliance was placed on clauses 28, 55, and 56 of the contract, which were pleaded in his payment claim and adjudication claim. So this was a claim post-termination of the contract. And the respondent, JKP, disputed the claim on the basis that the most relevant clause in the contract, clause 36.5, was not invoked by the claimant to support its claim. Now, the adjudicator agreed claimant's claim based on the clauses 28, 55, 56 could not be sustained, but allowed its claim based on clause 36.6 of the contract for the sum of 800,000 plus. So just for completeness, clause 36.6, it actually talks about the professional fees, which is actually claimable by Anas, depending on whose fault lies or the completion of the work. If it can be determined under clause 36.6 that the work has been performed completely, then it's of course Anas is entitled to be paid, and vice versa. And what happened, of course, was that application to set aside the adjudication decision was actually dismissed by the High Court. Application by Anas to enforce the adjudication decision as a court judgment was allowed under Section 28, and JKP appealed to the Court of Appeal, which reversed the decision of the High Court. Now, the Court of Appeal here held that the adjudicator have actually exceeded his jurisdiction, deciding the case on an unpleaded clause, and also breached the rule of natural justice by failing to invite parties to address clause 36.6 of the contract. Now, leave to appeal to the federal court in Anas was granted on 3 questions of law which is summarized a bit below. First question was whether the strict rules of pleadings, as in the Malaysian courts, apply to adjudication proceedings under the CIPAA 2012. Second question was whether the dicta in view esteem prohibit an adjudicator from referring to a specific clause in a construction contract when allowing the claim, when the said clause was not specifically stated in the payment claim and adjudication claim. Thirdly, in a CIPAA award, does the adjudicator's consideration of an unpleaded clause in the construction contract without inviting parties to further submit on the said clauses amounts to a breach of natural justice or an excess in the jurisdiction? So these were the three questions of law posed to the federal court in Anas, and it was a split decision. Majority decision was by Abdul Rahman Sepsabi, Chief Justice Sabah Sarawak, and Learned Federal Court Justice Nordin Hassan. Minority decision was by Justice Mary Lim, which we will examine in a short while. So the federal court here affirmed the decision of the Court of Appeal, set aside the adjudication decision. It was held that it was unnecessary to answer the questions posed by the appellant to decide the appeal. So the federal court decided as follows. Under section 27 sub 1 of CIPAA, which we have seen just now, jurisdiction of an adjudicator is limited to matters referred to by parties to the adjudicator pursuant to sections 5 and 6 of the CIPAA. Now, section 5 that we have seen refers to payment claim. Section 6 refers to payment rate response. And then the federal court went on to examine section 5 sub 2b of CIPAA, which requires the claimant to include in the payment claim the cause of action, the provision under the contract to which the payment relates. Thus, the claimant must identify the cause of action and the provision under the contract that supports the cause of action. So this was how the federal court have dealt with the issues by examining section 27, section 5, and section 6. Now, then the federal court went on to decide that since the jurisdiction of the adjudicator is limited to matters referred to under adjudicator under section 5 for the payment claim, the cause of action under clause 36.6 was not relied upon in the payment claim. The adjudicator had exceeded his jurisdiction in deciding the dispute based on clause 36.6 of the contract. The cause of action under clause 36.6 was not Anas' case in the payment claim or JKP's rebuttal in the payment response. The federal court also held that both parties have also not given any written consent to extend the adjudicator's jurisdiction to adjudicate the matters relying on the cause of action established in clause 36.6 of the contract as required under section 27.2 of CIPAA. On this ground of want of jurisdiction alone, adjudication decision cannot stand. The adjudicator had acted in excess of his jurisdiction. And the federal court went on to also decide that parties were not given the opportunity to submit the cause of action under clause 36.6 of the contract before the adjudication decision was handed down. Principles of natural justice includes allowing parties to actually submit on the present the case effectively. In these circumstances, there had been a breach of natural justice. So as a result of the decision in Anas now, we would appear that whenever a party launch a payment claim under section 5 of the CIPAA, or file a payment claim or serve a payment claim, it must actually very succinctly put out all the relevant clauses in the contract that is relying upon. Now, then we can have a look at the dissenting judgment by Federal Court Judge Justice Mary Lim, as the leadership then was, who delivered the dissenting judgment. If you have time, I would strongly encourage you to actually read the dissenting judgment. It is very lengthy, but it's very well written, where her ladyship have actually examined the case laws from other jurisdictions, particularly in England, to see what is the background of CIPAA and what was the intention of CIPAA when it was enacted in Malaysia. Now, her leadership answered all three questions of law in the negative and held as follows. CIPAA is intended to provide an intervening provisional decision in appropriate circumstances in favor of those who claim payment. Final determination of a payment dispute lies in arbitration or in litigation. Now, her ladyship, Justice Mary Lim, have recognized that, look, as far as CIPAA is concerned, it is just meant to provide an interim solution It's a rough justice sort of situation. Her ladyship also refer to the case of UDA, when it's meant to be a quick and dirty interim solution for the case. And more importantly, Justice Mary Lim also recognized the fact that under the CIPAA, the claimant or the parties, to be more specific, could represent themselves. They could also engage representatives to represent them. Basically, could be claim consultant or could be a legal firm to either act for the claimant or respondent. And this, as opposed to a court matter, where if you are a company suing or being sued, for example, you must appoint a legal firm. There's no such restriction under CIPAA. You can actually defend the matter yourself or appoint a non-lawyer company, claims consultant, to defend it. So in this type of situation, in a nutshell, what her leadership is saying is that, look, should we have such a straight jacket approach or such a strict interpretation for CIPAA? We don't apply the rules of pleadings of the court in CIPAA proceedings. Do we actually seriously, do we expect a layman, for example, or a non-lawyer to actually go through all the technical and procedural issues under CIPAA just to launch a payment claim, which is, in her leadership's words, is akin to a letter of demand? Because once the other party receives the payment claim, if they decides to pay the non-paying party, that is the end of the matter. The matter won't even proceed to the adjudication claim stage. The leadership also held that the purpose of identifying the cause of action in clause 5 sub 2 sub B of CIPAA is to ensure that the non-party is able to respond and that the details should be sufficient for its purpose. Now here, the leadership held that as far as JKP, the respondent, is concerned, they have no issue at all in filing the adjudication response and addressing each and every issues that have been raised by the claimant. So therefore, the requirements of the payment claim here, or the purpose of the payment claim here, had actually been satisfied by the claimant. More importantly, point number 3, her leadership also held that after combing through all the adjudication documents, that the relevant clause 36.6 of the contract had actually been referred by Anas in the correspondence exchange with JKP, and these letters were cited in the payment claim and the adjudication claim and form part of the supporting documents. What Anas did not do, however, in this case, was to actually cite the clause 36.6 in the payment claim or adjudication claim itself, but it was actually found in the correspondence between the parties. Therefore, again, what the leadership is saying that JKP was never caught by surprise by the contents of the payment claim or the adjudication claim. Her leadership also went on to say that JKP themselves, being the respondent, had referred to a clause 36.5 of the contract in the adjudication response, and it would be unreasonable to insist that the adjudicator wear blinkered lenses, ignore the rest of clause 36.6, which was referred to by the adjudicator. The leadership also said that the dicta in view esteem has been misappreciated by the Court of Appeal. The fact of the decisions, federal court decision in view esteem, is simply that the adjudicator's jurisdiction in relation to any dispute is limited to the matter of the claim, which was referred to adjudication under section 5 and 6. The subject of the claim is the limiting factor. For example, in view esteem, they say that if the claim is talking about progress claim number 28, therefore, whatever claims and response that the parties are going to embark on or argue upon must be limited to progress claim number 28. And that is the only limiting factor. And here in Anas' case, as far as Justice Mary Lim is concerned, the subject of the claim is talking about the claim for professional fees by Anas. That is the crux of the matter, the subject of the claim. It is not talking about any particular clause of the contract. And finally, the leadership also held that, look, as far as Anas' claim was concerned, was made post-termination, so there was wide reliance was placed on clauses 55 and 56, which talks about termination cause upon termination of the contract, so on and so forth, and invocation and rights of remedies pursuant to these clauses. Now, as far as the clause 36.6 of the contract is concerned, as far as the minority decision is concerned, it was actually held that it has actually no real bearing of the claim. It was not a material issue. It was more of a peripheral issue. The main issue was actually the termination under clause 55 and 56, and clause 36.6 is actually talking about the entitlement, how much that the Anas can actually claim in the circumstances of the case here. So based on this situation, the question now is that moving forward, what should be the correct approach that a claimant would have to do in order to protect themselves when they serve a payment claim? How would we move forward after the decision of Anas? Do we actually have to cite each and every relevant provisions in the contract, or any provisions which may not even be directly on point, we have to cite it, failing which there is a danger that when the matter is referred to the High Court or Court of Appeal, it could actually be set aside for excess of jurisdiction or for denial of natural justice. Where do we actually move from here post Anas? And could a situation now arise? Could a layman or a company or a individual, for example, or sole proprietor, can they actually now file a payment claim on their own without relying on claims consultant, without relying on appointing a legal firm to act for them? Is it safe for the claimant to do so, bearing in mind the strict requirements which have been set by the federal court in Anas? This will all be discussed later, I believe, in the Q&A sessions between the panelists, and also when we address any questions from the floor on this issue. With that, I've ended my presentation. Thank you very much. Handing back the floor to Mr. Shantamohan.
Thank you, Wong. That was a very well presented presentation, and I think you fleshed out the issues really on how we move forward. Are we going to be technically and very strictly confining ourselves to strict pleadings in the inverted commas sense, or are we going to allow it to be previously, as it was, not such a strict interpretation of payment claims? I suppose we have nicely rounded up. We've laid the foundation for Serene to come forward with all her options of how we should consider looking at post-Anas payment claims. Over to you, Serene.
All right, thank you. Just give me 1 minute. Let me just put up my presentation. All right, good evening, everyone. I also agree with my fellow speakers. Thank you, BicTok, for inviting us. As we would like to complete within time, I will just move quickly into the practical steps on how we can now start drafting our payment claims post Anas Construction. I think Mr. Wong has gone through the judgment of Anas Construction in detail. In summary, it's basically the adjudication decision was set aside because the adjudicator had relied on a contract clause not cited by the claimant in its payment claim. Whether you agree with the majority or you agree with the minority judgment, as legal practitioners or as users of CIPAA at this moment, we should take note of the majority decision and what is required of us. So in your payment claim right now under Section 5, which was also discussed by Dinesh earlier, Section 5.2 is explicit in what you need to include in your payment claim. We're going to go through, okay, so number C and D, description of work or services and a statement that it is made under this act is generally not so controversial. Now, 12 years down the line, most people can get that right. There's no issue of putting the fact that this is a payment claim made under CIPAA Act. But now with Anas, I would say that the issue is sub 2A and B. So in your payment claim, if you are drafting it, whether for your own company or you're a legal practitioner drafting it for your client, firstly, you need to be very clear what are your sums claimed and the due date for payment of the sum. Now, for some claim, it's not so much of a problem because usually your client or whoever will already have the accounts. The first challenge that you need to be very sure and ensure that your payment claim is clear is actually the due date for payment of the sum. So how do you calculate the due date for payment? You have to look into the term of your contract on when the period of honoring payment is supposed to be. Let's say it's 30 days from the date of the certificate, then it will only be due past that period of honoring payment. If it's whether you could check whether it is 30 days or 45 days or 60 days after, this would need to be properly stated in your payment claim. And please check your amendments or preliminaries to a construction contract. For those of you who may not be as familiar with construction contracts, there's a letter of award, and there's usually perhaps a PAM contract or even a FIDIC, but there may be amendments and supplementary clauses in the preliminaries or at the back. So you need to double check on those in order for you to be very sure that there are no changes or amendments to your due date for payment. So that's number one. You need to calculate whether it is post-certificate. You need to check whether it is post-invoice. So if it's post-invoice, then perhaps you need to then decide on whether your client or you yourself have actually submitted an invoice. In a matter of caution, usually I'll tell my client that if it's clearly stated that your period honoring period begins after invoice, then you will have to issue the invoice. Most contractors, especially the smaller contractors, tend to delay this issuance of invoice due to tax purposes, because I mean every invoice would have a lot of financial bearings on them. But if they want to go under CIPAA, then and their terms of the contract states that it is a certain number of days post the submission of an actual invoice, then they will need to put that in before the days actually start counting. And if you're relying on a Section 36 default provision, I don't have the actual section on my slides, but you can just check it out. It's a provision where the Act provides that if there is no payment mechanism, that means the contract is not clear on when the due date is, you can rely on this default clause under Section 36 to say that it would be deemed to be 30 days post your invoice. In a practical term, most of our payment claims, or at least for myself when I drafted, this Section 36 would be an alternative argument for a due date of payment. This can be a little bit, in a way, be a catch-all in case you did calculate your due date wrongly, or where there's some confusion in your due dates. All right, so then you should cite Section 36 in your payment claim. So any alternative due dates that you can think of because due to some confusion in your invoice date or confusion in your certificate date, then you must state it in your payment claim, or I would advise you to state all the alternative dates. That means, for example, you're going to put in your payment claim to say that this payment of 1 million is due on the 31st of October 2025, or alternatively 11th of November 2025, or based on this clause on the 12th of December 2025. So put all those into your payment claim, because now that we have Anas, the majority decision, it is always more advisable to be more detailed in your payment claim than to stick to a very brief payment claim as before. So gone are the days where we can just put in a very brief payment claim and then say that, oh, I'm going to just keep all this. I'm not going to show all my cards until adjudication claim. Don't do that. So please put in as much detail as you can in your payment claim. So that's A, that's your sum claim and your due date for payment. The second challenge comes is the identifying of your cause of action, which is one of the main arguments when it came to Anas due to clause 36.6. So in identifying a cause of action, the case has says that the claimant must identify the entire set of facts that gives rise to an enforceable claim. And the phrase comprises every fact which, if traversed, the plaintiff must prove in order to obtain judgment. So you have to give a bit more, for lack of a better word, a bit more meat to your payment claim to explain why, which clause you're relying on, what's the breach, how has a non-paying party breached those clauses in your contract. Okay, you cannot just dump clauses in. I would advise against it, So some people have come to me and said that, oh, with Anas now, I'm just going to cite all 40 clauses of the contract. That should cover everything. I would advise against it, because the course of action, you have to actually narrate a little bit on how succinctly, but still linked it to where the breach is. There must be a set of facts leading to the breach. So it's the judgment Anas Construction appears to indicate that the court wants more detailed payment claims or relevant facts, contractual clauses to be canvassed in the payment claim. So if you're drafting it, some of the things that you need to take into account is, if I'm claiming for variations, where is the variation clause in my contract? Put that in. Okay, obviously the payment clause has to be in, that's your default. You have to put in the payment clause when payment is due, variations, or you're claiming for additional expenses arising out of variation. So that if you're relying on a PAM contract, that's a separate clause altogether. So you cannot just say that I have cited 11.1, you have to also cite the specific clause, if I'm not mistaken, it's 11.7 in PAM contract, where you are asking for additional expenses arising out of a VO. And one of the ones that I think most of us may miss out is a claim for late payment interest. Later, we will look at one of the cases where this was a slight issue, but now that we have it clarified, I would still advise you to ensure that if you're claiming for late payment interest, contractual late payment interest, again, I use a common contract, which is PAM. You may have your own bespoke contract or your own contract, but under PAM, there is a clause that allows the contractor to claim for late payment interest, and you will have to cite that in your payment claim post Anas now. Okay, so that would be a few things that you need to include. Another example is you're asking for the release of retention monies. So you cannot just say that I'm claiming for retention and then the amount. You actually have to narrate a little bit on which clause that states the release of retention monies. Let's say it's upon CPC for your first moiety, then you will also, in your narration, will also state when was CPC issued, or when was CMGD issued, or when CMGD ought to be issued. So this sets of facts needs to now be in your payment claim. Okay, so you need to be a bit more accurate. So now we will look at two cases that have come up post Anas. Previously, I was thinking to show you an example, but because most of adjudication are confidential, I can't show you some of the examples of the payment claims that we drafted. But good thing is there are two cases that I can find online where it's now reported. So I can actually show you what was their payment claim there. So first is the case of Samsung against Berkat Honeywell. So in this case, I have put their payment claim, which I could extract out from the e-judgment documents there on the right-hand side. So in this case, they went through the whole adjudication, got the decision, but it was set aside. The court held that the payment claim was invalid as it failed to comply with the requirements under Section 5.2 of CIPAA, failing to set out the due date for its claims, as well as the relevant contractual provisions in its particulars of claim. So these two reasons are given in the High Court judgment on why this decision was set aside. So if you look at the right-hand side, for those of you who are a bit more familiar with CIPAA, you would instantly recognize that this looked like the suggested form in when CIPAA was first introduced by the KRRCA, the AIAC. This was the suggested form. So what happened here is, I believe Berkat Honeywell just took that and just inserted the figures into this and then just attached the schedule, the documents in their payment claim, and did not actually state in the payment claim when the due date is, or to explain or narrate out the contractual provisions, not even talking about the facts. Now, the payment claim did not even actually set out which clause are they relying on. So be very careful if you are just going to rely on it's a suggested form, but doesn't mean that you don't need to look at it further. So this is a correct structure to put it. This is good enough. Also, the relevant contractual provisions and the due date. I think that would have met Section 5.2 requirements. With Section 5.2 requirements, although now we all said that it needs to be in detail and all those, but the courts have not advocated for a overly detailed payment claim. They just need Section 5.2 to be satisfied. So in this case, it was not. Then another case, also a 2025 case, Mayfair Ventures, again, the losing party brought the same argument up to the High Court and said that, oh, the payment claim did not comply with Anas Construction because the clause for the late payment interest that was granted is not cited in the payment claim. So the High Court in this case dismissed this argument for reasons include, amongst others, that the fact that the late payment interest had been referenced in the payment claim. So I've extracted the part of the payment claim that I can find from the documents. If you look at paragraph 24 on the left. So what happened here is that the unpaid party said that the amount claimed is 8.8 million and the due date for payment of the amounts claimed by our client shall be as stated in the paragraphs above. That actually set up the due date in a table form for each of the unpaid balance of progress work done in the certificates and the late payment interest calculated. So, and then in paragraph 25, they referred to clause 30.17. This is a PAM contract, so I think 30.17 is the late payment interest condition in the contract. So the losing party was unsuccessful. I mean, this adjudication decision was enforced. I have put both of these payment claims side by side. You will get a copy of these slides. I think it's important for you to just have a look at it. I've put Samsung's Berkat Honeywell's payment claim on the left, and Mayfair Ventures, I've also separated out into how they have complied with 52A, B, C, and finally D. So when you are drafting your payment claim, I think you have to have this in mind and go through the checklist of A to D carefully, and so that you do not need to deal with a jurisdictional challenge at the end of the day. I mean, right now, this is the law that we have. I don't know whether it's going to be amendments or clarifications in the years to come, but as it stands, this federal court decision is valid and we should follow the majority decision that was out. So these are the summary that I can give you before I end talk and we take some questions. And I think one of it that I need to highlight is if you're representing the respondent. So previously, many years ago, a lot of respondents will always complain that, oh, there's nothing I can say. I'm just going to keep quiet. I'm just going to put in a payment adjudication response. I think right now, if you are representing the respondent and you received a payment claim, you will also have to go through and check whether Section 5.2 has been complied with. And then you raise this issue at the very beginning, that you're going to raise a jurisdictional challenge. The adjudicator, of course, can still proceed with it despite there being a jurisdictional challenge, but this at least gives you a room to raise this again at the High Court, to say that you have already notified or raised this issue of jurisdiction at the beginning. So if you are representing the claimant and you realize your payment claim clearly does not comply with Section 5.2, I would advise you to not proceed to the end. You please, I mean, as a matter of consideration, but I would consider and advise my client to withdraw it and to issue a new payment claim that complies with all the requirements of Section 5.2 so that we can then proceed with the adjudication decision. It is sad if you go through the whole thing and you win and you get set aside on this just because you did not want to redraft your payment claim. That's just a personal advice. If you have realized that you did not comply with it, then consider withdrawing it and reissuing a new payment claim. So that's all I have for this section, Mr. Shanta.
Thank you, Serene. That was a very nice comparison of how the courts have a couple of decisions of have gone either way. But I think the Mayfair case has actually put out the payment due dates and also the relevant process. So I think that's the way forward. Now, I wonder whether there's any questions. I'm looking at the chat group. Okay. Okay. All right. Okay. Yeah. I just want to put to the analyst this question about. Of course, the majority decision says that we have to go more strictly in terms of. Hang on. I think there's a question on the chat box. So let's see. Okay. I think the question by Charlene Chu has come up. Maybe I'll just post that question. in what circumstances can a decision be set aside on the basis of conflict of interest or appearance of conflict? Not sure how that's relevant with jurisdiction, but never mind. Maybe they're tapping into the panelist experience of. Anybody want to take this question?
Maybe I'll start off and then
you can start first. Ladies first, sorry.
since there's a question, I think firstly, okay, before you even reach the setting aside, when the adjudicator is appointed, and the adjudicator then states out the matter of conflict or whether it was raised. If you are representing any other party, that's your very first chance to actually raise an issue of a potential conflict of interest. Okay, and appearance of conflict is a bit tough because I mean, you can't, but if there's a conflict of interest or a potentially conflict of interest, usually you raise it there and then so that the adjudicator can then say, all right, I'll resign. The AIAC can then appoint another adjudicator. I think that is the prudent thing to do. But if during the proceeding, things come up and you realize that there is a conflict or the adjudicator found out there is a conflict, they can still do so. So when the decision is given and there is a conflict of interest, this is not a ground under Section 15 strictly. Okay, but under Section 15, there is a ground for to say that the person has not been impartial or there is partiality. And some have, over the past years, some have tried, none have succeeded to actually prove that the adjudicator was partial or was siding one party for another in terms of the layman terms, and that it was set aside based on that ground. So that's all I can think of in terms of conflict of interest. Is not exactly a ground under Section 15. Yeah. Anyone wants to add on?
Maybe I can share an experience that I had actually in an adjudication. Not quite. There was I called for a preliminary meeting on the first. Normally, I do a practice of calling parties in for a preliminary meeting to give directions and to see how we're going to proceed with the documents. So at the preliminary meeting, sitting second chair is a cousin's daughter who just joined the firm 2 days before. Okay, so obviously the claimant solicitors knew probably the link, or didn't know, I don't know, but I found as the arbitrator, as the adjudicator, that I had to divulge and tell the parties that, this is the link, and, if you all are comfortable, I will proceed. Otherwise, I will resign. So the claimant, of course, had no problem. The respondent said he'll need some time. And of course, they came back and said they were not so comfortable. But the moral of the story, I think, for adjudicators as well, if there's an apparent conflict, or I think it's always good to raise it to the parties there and then, rather than it going through a full adjudication. A decision is delivered and then later it transpires that, so-and-so was working in a firm and, it's related to the adjudicator and, it was not divulged. The critical thing is, it may be nothing, but it has to be raised and have the parties address it. And if they're comfortable with it, they move on. Otherwise, they find another adjudicator, that's all. Of course, there's a loss of fee, but then again, reputation is worth a lot more than fees. So I think that is, if anybody has any input on this. Otherwise, I'd just like to throw this broad question about how, when CIPAA was introduced, it was designed for a speedy mechanism for unpaid parties to obtain payment. And it was the process, like I think Inlo was mentioning, you have lay people not legally trained. The idea was CIPAA was to enable non-legally trained to file their own payment claims and or with the assistance of maybe a claim consultant. Now, in looking at Anas' decision, the question I would like to pose to the panel is there room for lay or non-legally trained claimants to file a payment claim? I think that in a nutshell is the concern that a lot of people are asking this question. We can hear from either all three of you all what your thoughts are.
You want to start first, Rin?
Hey, Wong,
The
you
last
can't be doing
question.
this
Your
for
turn.
ladies.
Sorry?
You can't
Oh,
be
yeah,
doing this ladies first all the time.
Oh, I mean,
Not fair.
my prelim view is that it's very difficult for a layperson now to actually initiate a payment claim or adjudication claim by himself. I mean, we have seen over the number of years, quite a few adjudication decisions, quite a number has actually been set aside. And the claimants in those cases were actually represented by a legal firm, by lawyers. So even the lawyers themselves couldn't get the payment claim or the adjudication claim right, you see. And those decisions has been set aside. Those could range from issues like because the claimant was claiming for performance bond or bank guarantee. I'd done one case before we managed to set aside because the claim was actually for a refund of the performance bond or bank guarantee that the employer had called on the bank guarantee. Then the claimant, being the contractor, said, "Oh, I'm clawing this back under CIPAA," but it's not a construction work done under construction contract. So that was set aside. Another case was where there was a something akin to a settlement agreement between the parties. Then that which resulted from a construction contract, that also was set aside by the High Court because the High Court said this is a settlement agreement between the parties. It's not for construction work for work done. You see, so all these were actually. And all these payment claims and adjudication claims were actually launched by lawyers, were filed by lawyers, and they also couldn't get it right, unfortunately. So I'm sorry to say that there's not much hope for the man on the street then to actually launch a payment claim if it's more technical and a bit more difficult, because they really cannot see actually under Section 5 is coming a bit more technical, I would say. I mean, that is my view. That's my view.
Good news for lawyers like us. Well, there'll be more work coming your way. Yeah, Dinesh, any input or thing?
Yeah, I mean, I echo what Mr. Wong said. I think it's going to be very difficult post Anas, because I mean, before that in itself, Section 5 sub 2 was very specific on what elements it required. And even then, the courts were quite relaxed with those elements. But now post Anas, I mean, we all know the man on the street are not all lawyers. And the usual defense, ignorance of the law is no defense. It's going to be very tough for the men on the road to deal with this on a legal point of view. But yeah, I mean, I guess long story short is engage a lawyer. But like Wong pointed out earlier, even lawyers are making mistakes. So pick a good lawyer, I can say.
Okay. Serene, I've got this question for you. I think you raised this very interesting point about the CIPAA, I mean the act, the AIC booklet that gives a recommended payment claim, and then they put a schedule there, Schedule 1, Schedule 2, Schedule 3, which is a common thing that's been happening from time, I mean, I guess as long as I can remember when I first started it. Now, is it time that AIC fine-tunes in view of Anas? Is that still a good precedent to have? Because I think if you look at what Marilyn's argument is, you say if you look at the correspondence, you look at everything, it's there. But the
that's a minority decision.
Majority doesn't look at it that way. They just look at Section 5, Section 6, and it's there, it's not there, that's it. It's very mechanical in the way they look at it. But I mean, that's the majority decision. So what are your thoughts about
so if you look at the suggested forms, you are supposed to still put a due date in your table. Just like I think in Berkat Honeywell, I don't know who drafted it, it was not in. So the forms do still comply with Section 5.2 on a very basic level. But having said that, because of how the Act has evolved over the 12 years, now you cannot just put that table in and say that I have done everything. Yes, you should still put your Schedule 1, 2, 3. I think that is not the issue, right? Because you are supposed to put your supporting documents where you can. And it's good to put in schedule. As adjudicators, we welcome it so that it is actually separated. But I think the table is not the problem. You need to ensure that the cause of action, which is your clauses, and your due date should still be in the table. I can't speak on behalf of AIAC whether they're going to come up with new forms. Of course, if more clarification is given, it's always welcomed by the industry. because this is the purpose of CIPAA. I mean, I echo what Mr. Wong and Dinesh has said about it being very technical, and you require lawyers' advice and to draft it properly. But there are some who may not be able to afford lawyers to actually draft it, and the whole purpose of this act is actually to also protect those contractors. So I do hope that if there's a way to go around it, I think we can help and to help clarify it as well. Yeah.
Okay, I'm going to ask a question from the adjudicator's point of view, because I think so far we've been looking at a claimant respondent point of view. From the adjudicator's point of view, I mean, if you look at Anas, I think the adjudicator has actually gone through the whole contract, and he's plucked up the correct section that under which he had allowed the claim. So obviously, he has got it right in one way, but he has infringed 5(2). So what is the advice? I think this one probably to all three of you all, because all of you all have said it, adjudicators. What's the best practice? How would you deal with Anas' situation as an adjudicator? If it comes before you as an adjudicator, how would you deal with this issue? On hindsight, lah.
I think for me, I would have probably sought clarification from the parties. I mean, in the process of me probably writing my decision or preparing my decision, and if I notice that a certain clause or a certain part of the contract has not been referenced by either party, I mean, my personal view is I would have probably written into parties and sought clarification on certain items, that whether these is being relied upon or whether it's closely connected to the claim, or what is their view on the other clauses of the contract. I think that is something I would probably do, which I've done for, I mean, not on clauses per se, but I've done before seeking clarification from parties before, which the adjudicator is empowered under Section 25. So I would probably have taken that route to seek clarification from parties.
Yeah, I think I totally agree with you in that sense. I think writing. But any other thoughts? Any of you all? I mean, you mentioned that Justice Mary Lim had given a very compelling position on why it should not be too technical.
Yes.
Would, in a situation like this, if time was of essence, and how would you deal with it?
I mean, of course, in a perfect world, the adjudicator will actually invite parties to submit on any point of law, any case law or authorities which are the decisive on point. For example, he will say, there's this case law, Federal Court of Appeal, which none of the parties have cited. It could be relevant. Can you give me your written submissions or whatever it is within 3 days or 5 days or whatever, or this particular clause, it could be relevant. Would parties wish to submit on this? Give you a timeline. I mean, that is in a perfect world. Sometimes, fortunately, some adjudicators leave it to the very last minute to write the adjudication decision. As matters before, when we have to call the case counsel for the EIA, so to say, the adjudication decision is due tomorrow. Today is the last day already, and there's no news at all. What happened to the? Can you please call the adjudicator and ask him or her? Is it coming out? Not the decision. Otherwise, we're the claimant here, whatever. So the problem is, of course, if the adjudicator, because of time constraint or whatnot, they are leaving the writing of the adjudication decision to the very last minute. That is the time when they actually look at the payment claim and adjudication claim and whatever. And that is the time they realize, oops, there's this issue or this point are not canvassed by parties. Does the adjudicator still have time or not to actually invite parties to actually put in additional written submissions or to submit on that point? So I think the preferred view is that even if the adjudicator is not going to write the decision so soon, at the very least, quickly glance through the adjudication claim, payment claim, response, authorities, and documents. Try to pick out what are the main issues which may require submissions or clarification from parties, and do it as early as possible, to bypass all the problems that may happen in Anas and whatnot.
Yeah. I think we had finished. I just close out. I think one thing that I wanted to just highlight as adjudicators, we also have to be very careful not to be telling the claimant how to draft their payment claim. When we are doing it. I think there is a very fine line on, we may see something there, but I think as adjudicators, we should not do it and should be very careful in how we frame clarification questions to parties. And that at the end of the day, it's a jurisdictional issue. We proceed to decide under Section 27, and then we let the courts deal with it at the end of the day. We just ensure that there's no breach of natural justice. We let everybody submit on all the clauses, as said by Dinesh and Mr. Wong. I think that there is always a tendency that sometimes we tend to, try to say that it's a technical issue. I think I'm telling myself also, I have to remind myself not to, to be careful, as adjudicators.
I think Serene, you raise a very interesting point, because see, the thing is, when you ask for a clarification, in a way, you're trying to, strengthen a claimant's position by asking for a clarification. So it can flip on the other side, where the respondent takes objection and say, look, adjudicator is now not being fair, because by asking this question, you're closing a loophole that was there. And by asking for that particular clarification, you are strengthening the claimant's case. So you then have this problem of whether you're in breach of natural justice, because you have to be impartial. So that's the dynamic that, sometimes you have to be extremely careful in how you, as Serene rightly said, how you frame the question and how you put it across. And anyway, that's always the challenge. Otherwise, you are challenged, that your decision will be challenged. So I think we've, come to more or less, we exceeded our time by 5 minutes. If there's no further questions from the participants, I see the chat box. I'd like to thank the panelists for spending the time and effort and, valuable time. All of you are very busy practitioners and for spending the time and preparing the notes and the slides. And I would hope that BicTok can actually share the slides. I think they're all prepared very well. I'd like to thank all the panelists and also BicTok for inviting us. Hand it over to Ellen for closing.
Thank you very much to our moderator, Mr. Shanta, and our panelists for the very insightful discussion. We hope you found the session of Anas Construction versus JKP engaging and useful for your practice and studies. We'll share the slides from today's session for your reference. And as a reminder, our next BicTok session will be held on 19th November at the same time at 5:30 p.m. to 6:45 p.m. on the topic of court annex and judge-led mediations, use and implementations in practice. Do keep an eye on BicTok's social media pages and website for updates on this and other upcoming sessions. We look forward to seeing you then. Thank you once again and have a pleasant evening.
Thank you,
everyone.
Okay, thanks, Serene, Wong, and Dinesh.
Okay, bye.
Bye.
Bye.